Yes, just really briefly, regarding her opinion of your husband, did you or did you not write him a note when you were taking the newborn?
Objection, outside scope, hearsay as well.
Okay, well, hearsay is allowed in a bond hearing, and I let the defense ask questions that were outside the scope. So your objection's overruled. I didn't hear the question, though.
Did you attempt to write him a message on an envelope telling him he was a good father, I love you, take care of the children?
I try to communicate, of course, because I have children with him, and yes, we have to communicate. You have to have that kind of heart because you have children. So yes, absolutely.
Did you write that note, I love you, you're a great father?
I wouldn't say the specifics of that. I would say again, I communicated with him, and again.
Do you disagree with what I'm telling you?
I'm not disagreeing with you. I'm just saying that I'm communicating with him, so I am agreeing with you. But to the specifics, I'm.
If I showed you a copy of it, would you recognize it?
Yes, I will.
You know what I mean? The defense has previously made you write a copy.
Karen, we would maintain a relevance objection in this as well.
What's the relevance of this?
Just her opinion of her husband as a good father, her need to communicate, basically break rules. She's trying to secret this note to him.
Okay, does it have anything to do with the conditions that I have to consider for bond?
Maybe in a collateral way.
Okay, well, tell me what they are, because I'm not seeing it.
Just her, she's going to do what she's going to do. Basically, she's hiding this note. She's not supposed to communicate.
Okay, there's a rule against not communicating, is that what you're telling me?
Well, she's in custody with the jail. It's not approved communication. She's hiding it in the baby's belongings to go to him.
Okay. All right, your objection's overruled.
But I do have a question concerning this. Is the state indicating that she was in the jail at the time that this communication was made and that he is accusing her of an improper, illegal transformation of, or transmission of information?
I didn't hear that. I heard that there was some sort of barring of communication and it was proving that she was going to do it anyways. That's what I heard.
But is there a no contact order? There has not been one. So what are we talking about here?
It's an improper communication. She's in the custody of the jail, even though she's at the hospital. And she's secreting a note in the baby's belongings.
Okay, so she wasn't in jail when she gave him this note. And are you telling me that, and you have something to tell me that there was, I mean, I don't know off the top of my head the rules of the jail. So are they not allowed to communicate? They can write letters, right?
I believe it has to go through the jail personnel.
Okay. So this was done when she was at the hospital?
Yes.
Okay. All right. The objection sustained.
Okay, I have no further questions.
We don't have anything further, Your Honor.
Okay. All right, ma'am. You can step down. Thank you. Defense, do you have any other witnesses? State, do you have some witnesses?
Could we just have one moment, please?
June, can you bring us back?
Yes, I will.
Judge, we were going to play one of the videos that's kind of out there already anyway. I just wanted to see if we could do it without having to go through witness authentication. I believe we can stipulate to the video, save a little bit of time.
I haven't seen any videos, so, but I want to say I have 15 minutes left. So that's, we can't finish it. We're going to have to.
It's about 5 minutes, and then we can probably wrap it up at this point.
And you call whoever you need to call. I'm just saying, we might have to continue that. And hold on 1 second. Do I see the father and the husband in the courtroom?
Yes, Your Honor.
Didn't I invoke?
I wasn't looking at this.
Has he been in the courtroom the whole time that there's been testimony going on?
He's been in for most of it.
Okay. So are there any motions?
None from the defense judge. He's not going to be called as a witness in rebuttal in any way, so I don't see.
State, is there any motions?
If you could step outside and follow the rule, I think we're about done.
Don't come back in the courtroom, sir.
Now, it doesn't show a whole lot of what needs to be shown. I would like to see a short one.
Either there's a stipulation or...
Well, we will stipulate to it being to the authenticity of it if the state wants to show it for the purpose of this hearing only. We haven't taken depositions to authenticate it at this point, but from what we're seeing, it's the best that we've got at this point.
Okay. So by stipulation,
No, by stipulation, can this go in as stage 1?
yes. What's it, is it A for identification?
Yes.
Will be enter as stage 1.
Thank you very much. Good, let's go ahead and publish this.
Yes.
You want the lights on or off, sir?
Oh, probably off. Shut it off.
state any other evidence?
Judge, I don't think so. I think we can make our arguments at this point with what we have and what's in the police reports.
Okay. All right, argument?
Thank you, Your Honor. Your Honor, for them to present some case law to the court and statutory law. In this particular case, the bond has been set extremely high, $1.2 million, as requested by the state at first appearances. First case I bring to the court's attention is this Patterson versus Newman case from the 4th District, 707 Southern 2nd, 946. In that case, the defendant was charged with sexual offenses on a child. They were not punishable by life imprisonment or death. They were charged or punishable by lesser or by a number of years. The defendant alleged that he had strong family ties, no prior criminal history, not a flight risk or danger to the community. And the defendant's counsel represented at the hearing that he could reside with his mother or grandmother and wife. They owned a home and could post a bond of $10,000 to $15,000. The state's only argument was that there was probable cause and that he confessed and asked that a $100,000 bond be set by the court. The court then did so, just setting a bond at $100,000. On page 2 of the opinion, at the bottom of the first column, it says, the purpose of bond is to ensure the appearance of a criminal defendant at subsequent proceedings and to protect the community from unreasonable danger from the defendant. That's what the two purposes of bond are, and that is what we're asking the court to consider in this particular case. The next case is Best versus State, 28 Southern 3rd, 134. This one's out of the 5th DCA from 2010, and in that case a $320,000 bond for aggravated assault, fleeing and eluding, and DUI had been set by the court. At the hearing, the court found that the defendant was an unreasonable danger to the community based on the fact that the charges involved violence to a law enforcement officer, and he had initially been charged with attempted murder of a law enforcement officer. The judge later stated that the bond set at $320,000 was tantamount to no bond in his opinion. That's the trial court judge. On appeal, the 5th District Court of Appeals, or on habeas, the 5th District Court of Appeals granted habeas and said that the court abused its discretion when it set an excessive bail that is designed to be a fundamental equivalent of no bail. The next case of Layton versus State, found at 55 Southern 3rd, 675, a $1.6 million bond was set, and it was held to be an abuse of discretion. The defendant was arrested for attempted first-degree murder, shooting into an occupied vehicle or structure, and use of a weapon during the commission of a felony. The testimony was taken regarding the factors that should be considered, which are set forth in 903.046 subparagraph 2. The defendant was 23 years old, he had no assets, and he earned $400 a week. Even though the trial court found
like they want to be together, although she does stand by her allegations of abuse, sexual abuse on one of the children. So there's a chance of intimidation and danger to the children. There was also testimony by the Dr. Danzinger, I think it was, yes, Dr. Danzinger, that his opinion would be that it would be better for the defendant not to be in jail, but just because the jail was in itself or anybody was stressful. She's not suffering any mental health issues right now that would make her more susceptible to problems in jail. on count one, I'm going to reduce the bond to $25,000. Count two is $25,000. Count three is $25,000. Count four is $5,000. Count five is $5,000. Count six is $5,000. If the defendant were to bond out on with those bonds, she'll be on pretrial release. She is not to leave the county of Volusia. She is to surrender any passport she has. There will be absolutely no contact with any child of hers. And that is directly or indirectly. That means directly contact, physical contact, Facebooking, texting, telephone, indirectly through family members, husband, no contact whatsoever. She is also to regularly see a doctor, a psychiatrist or psychologist. She must show proof that she is taking her medicine. That is either going to be through long-acting injections, which she takes, or blood tests. So it is not going to be someone verifying that she's taking the medication. It will either be through the injections or blood tests. I don't know what the dependency court, no one has told me what the dependency court conditions are. So no contact with the children, and the father of the children is absolutely not allowed to supervise any contact. So if there is supervision of contact in the other court, I'm saying no contact. We have to have a hearing on that if you want to modify that. If the defendant bonds out of jail, and in any event, even if we have a hearing on that, the father is absolutely not allowed to supervise any future contact that may be allowed with the defendant and her children. No drugs other than prescribed medicine, no alcohol, random UAs. She is to report into pretrial services weekly. Is there any other conditions, Mr. Purdy, that you want to see part of the pretrial release if she bonds out?
Judge, only that if, there was mention of a blood test as a possibility. We'd like to find out if possibly a urine test may suffice.
That's fine.
Something along those lines.
That would be fine.
Judge, we would also just point out that with her assets, that this is still tantamount to no bond. $75,000 on the three second-degree felonies, and $5,000 on the three third-degree felonies is still too much of a bond that for her.
June, did you get all that?
Yes.
Mr. Purdy, can you, your team please file the order?
Yes, Judge.
Okay.
Judge, we need to make any questions.
Oh, I hope so.
Judge, just one other thing, we'll probably just need to get a disc of the, of your ruling, just so that we can then put it into an order form. Today being Thursday, it may... All next week? Okay. Tomorrow too? Okay. All right, we'll try to get it done as soon as they can make us a disc. Hopefully they can do it by this afternoon, and we'll get to work on it. Thank you, Judge.
Thank you.
Done deal.